Morning, everyone. I think we'll get going, given everyone a few minutes to join. Welcome. For those who are new to us, at Ignition, we run a series of know-how webinars throughout the year, and they fall into two camps, really. Firstly, our general counsel know-how program, which has got a legal slant, and secondly, our commercial conversations program, which is more of a commercial leaning and aimed at SMEs. And today is our first commercial conversations session for 2025, which Anthony Davies is very kindly helping us with. He is head of tax at UHY Hacker Young, and Anthony's going to talk to us about key tax challenges in a global economy for 2025 for SMEs. We are adding people as panelists where we can, so they can ask questions themselves. But if that isn't working, then just pop your questions in the chat and we will keep an eye on the chat as we go through. But over to Anthony. Thank you.
Thank you, Tammy. Thank you very much. Thank you to Team Ignition Law for inviting me along to come and have a chat with you all. We are definitely seeing a huge shift in the global economy and more access for SMEs to access global markets. So when I first spoke to Alex about what to speak about, and he suggested that maybe looking at some of the tax concepts and understanding some of the tax challenges that SMEs face as they move into a global economy may be a good area for to cover on one of these seminars. Just a little bit about me. As Tammy said, I lead the tax team here in the UK for UHY. I also chair the international tax group for UHY International, which is our international network. We are the 19th largest network in the world at the moment, and operate in pretty much every major jurisdiction. My background, I've led tax teams for in-house for large international businesses, and then I've led international tax teams and accountancy firms for probably the last 10 or 15 years. So I deal with all sizes of businesses. We deal with lots of high growth entrepreneurs and SMEs, but also large listed businesses across the UK and into other jurisdictions as well. Certainly we've seen a large increase of movement of businesses, but also movement of employees cross-border. COVID has been a large precursor of this. Hybrid working, we had a massive spate of people wanting to work abroad, wanting to go back home as they came from different countries, or maybe just wanting to work from other jurisdictions that they consider to be slightly nicer, maybe than London. And this created all sorts of tax issues in our businesses. But I think there's been quite a lot, and I think everybody will agree, there's been quite a lot of advances in technology, and they seem to have fast-forwarded quite a lot since COVID. AI is on the tip of everybody's tongue and continues to develop and drive technology forward. And all of this advancement is just making that market easier for small businesses to expand into. Historically, moving cross-border was a very expensive operation, and therefore was really only available to very large companies. That's certainly not the case anymore. Unfortunately, the complexity of cross-border tax doesn't change dramatically depending on the size of the company. It is complex. There are aspects of international tax that are only relevant to the largest of businesses, but it does increase the complexity of a business's tax affairs if they are moving cross-border. We're going to cover some aspects of this, but as you'll appreciate, it's a very complex area. It can be dependent on the type of business, and obviously every country has slightly different rules, so it can be specific to the client and the country that they're particularly operating in. So we can't cover everything, but we'll cover some basic concepts and hopefully give you a good flavour of the kind of things that either you should be thinking of, or if you're advising clients, what the client should be thinking of. Just a few trends and statistics that I think are quite interesting. UK SMEs that export internationally tend to grow 20% faster than those that operate slowly in domestic markets. I think businesses that tend to operate in international markets will generally grow, whether they're exporting or whether they're providing services. It's just opened up a hugely vast market for them to operate in. 232,000 SMEs in the UK exported products into foreign markets in 2017. Sadly, we don't have a huge amount of comparison in current data. The UK and the National Statistics Office isn't massively up to date on some of this information. So I suspect the number dramatically increased during and after COVID. And there were 2.7 million registered SMEs in the UK, with 322,000 exports of goods and services in 2021, roughly a 40% increase from 2017. I'd say the data is a little bit old. We're in 2025 now. I suspect those numbers have gone up significantly. Certainly, looking at the clients that we deal with and the advice that we're giving, there are lots more businesses looking at how they can expand in foreign markets. Some of the key topics that we'll just look at as part of this webinar, we'll probably spend maybe half an hour or so going through some of these topics. Please do feel free to put any questions as we go along, and I'll try and pick those up as we go along, and then we'll leave hopefully kind of 10 or 15 minutes at the end just to ask any additional questions if people want to jump on and ask questions. But we'll jump into the first one, trading with versus trading in. How will this be viewed locally by the tax authorities and why it matters? There are different ways that we can have a presence in countries, and they massively impact on the tax implications. So we'll have a brief run through permanent establishment, residency branches, representative offices, and what these are. They often get mixed up, and people use the same terms for different types of presence, which can have different tax implications. I think it's important when we talk about anything relating to international tax, that we talk about double taxation, double tax treaties. What are they? How can they help us? This might be a surprising topic, but we are going to have a very brief chat about what BEPS is and transfer pricing. They are things that people think are only applicable to large companies, but you might be surprised at some of the knock-on effects of the legislation and the policies that are in place for some of those programs do have an impact on smaller businesses. Particularly employees moving cross-border is a key consideration, and often the most important thing to get correct. If you can't deploy your employees into the right locations and pay them correctly, make sure that they feel looked after and look after the tax implications for them, it's going to be a challenge to move these cross-border territories. I'm not a VAT expert. Good service tax and sales taxes, withholding duties on import and export. They're always a challenge. We'll talk very briefly about them, but it isn't my area of expertise. I'm very lucky that we have a very competent VAT team here at UHY that handle that area because it is hugely complex. Let's kick off with the first concept, and it's the very first concept that you learn as a tax advisor when you're dealing with cross-border activities is, am I trading with someone in that country, or am I trading within or in that country? And the tax implications are very, very important. If I'm trading with a customer in that country, I don't have a local presence often. I'm clearly subject to tax in my local territory. In this situation, I'll assume that everybody's UK, based in the UK, and therefore UK tax is the predominant tax for each entity because we're based in the UK. But these concepts apply equally to other jurisdictions as well. Often it'll be subject to VAT. I'll probably have worldwide reporting issues. We'll talk about that a little bit later on. It's become much more of an issue since we left the EU. But thankfully, we still are part of the EU for some reporting aspects of VAT, which can simplify the position. Employment taxes, which will trading cross-border with a foreign customer, we have no employees in that foreign jurisdiction, then our employment tax issues are going to be simply UK only. The foreign customer, they're going to be subject to VAT locally and possibly import and export duties worldwide as well. So a relatively simple position for them. Compared to if we're trading in that country. So if we have a presence, and then the distinction here is I now have a presence in the country where my customers are based, whether that's an office, whether it's a permanent establishment. Again, we'll talk about the differences and how they can be created. But ultimately, I've changed the complexity of my tax position as a business. So if I'm a UK company and I set up a foreign office or a establishment or even a subsidiary in that country, I'm going to be subject to corporation tax on a worldwide basis. And I've got a risk, particularly if it's a permanent establishment rather than a limited company, but I'm going to be subject to tax on the same profits in two jurisdictions. So we'll talk about how we can take some relief from that. The general concept of double tax relief and double tax treaties, which we'll come on and talk about, is that I should only be taxed in one jurisdiction, and none of my profits should be subject to tax in multiple jurisdictions. Sadly, it doesn't always work out that way. There are lots of scenarios where double taxation comes into play, and businesses need to be aware of when that might be the case. I'm still subject to VAT on my worldwide income and potential reporting issues. One of the key things that happens when I start trading in a country, particularly if I'm not resident there, if my company is not resident there, often countries have de minimis limits before any business has to register within that jurisdiction. They do not apply if you're not resident in that country. So if I'm a UK company trading through a foreign office, I may actually be subject to VAT immediately on sales. As you can imagine, it can become quite a challenge to make sure that I'm reporting and paying VAT to the correct tax authorities, particularly if I'm trading in multiple jurisdictions. There are software solutions and companies out there that will help you to make sure that you are compliant if you're subject to VAT in multiple jurisdictions. So it's not all just left to the company to make sure that they register and comply and report tax and file tax returns in the correct jurisdictions. It is possible to get some help. And also, if I've got a presence, I'm probably going to have employees there, and I'm going to be therefore subject to employment taxes in that local jurisdiction. As a business, I'm probably going to have to register and understand what the requirements are in that jurisdiction. But there may be different social security requirements. There'll certainly be different tax requirements, but also things like minimum wages and what benefits need to be paid become important aspects. And therefore we need to be aware of that and require a business to then probably take some advice locally on what they need to provide for employees. Foreign customers, possibly some withholding taxes depending on the services that have been provided, and again they're going to be subject to VAT on the services that they buy from businesses that are located. So in summary, if I'm trading with a customer in a location, my taxes are likely to be much simpler, less registration requirements, less administration. I'm probably going to be less likely to have international employees and be subject to employment tax in multiple jurisdictions. Where if I'm trading in that country and I have a physical presence there, it's certainly going to be more complex. We have double taxation issues. Need to consider the treaties, transfer pricing, which we'll talk about shortly. I'm likely going to need to register and file returns in multiple jurisdictions. And as a result, the admin cost of running my finance function is going to be higher. Employment tax and social security are likely to be applicable in those jurisdictions, and we need to understand the minimum local standards that I mentioned earlier. So how do we create a presence rather than just trading cross borders? If I'm selling online, if I'm an Amazon Prime retailer and I'm just selling my products and I'm shipping them, I'm unlikely to create a significant presence in that country. So what does represent a tax presence that creates this more complex tax position for my business? There's a number of different ways that I can become present in a country for tax purposes, and we are talking about tax purposes rather than a different legal definition of presence in a jurisdiction. And the first one, and normally kind of the least offensive in many ways, is a representative office. It's not usually a different legal entity. Often it's back office function, so people open representative offices up in jurisdictions when they're testing the marketplace and they want to enter into that marketplace to see maybe whether their products could work in that marketplace, what competitions there, and maybe they're not quite ready to set up a branch office or a subsidiary at that point in time because they haven't determined whether they think they'll be successful in that particular jurisdiction. Representative offices aren't recognised in every single country, and it's important to understand the countries that do recognise them, because often they come with significant tax benefits, i.e. the activities are not subject to tax, but they come with strict rules and that apply to them to make sure that it is still considered a representative office, and we haven't moved on to some other form of establishment, such as a branch or an office. So usually there won't be any tax to pay on a representative office, but not always the case. And there's always an issue as that representative office grows into a proper fully fledged business. There's good where the cut-off is from being a representative office to being a permanent establishment or a branch. And it's always quite interesting speaking to clients and even debating with tax authorities in certain circumstances to understand the different views on kind of where that cut-off is. It's obviously clearly important to get that right, because when we move into being a permanent establishment or a branch, then that will become a taxable position or presence within the country. Typically, a permanent establishment or a branch isn't a different legal entity; it is just one entity. But it's a fixed location. Fixed is important. There's an element of permanence to it, and it is fixed in that location where business is carried out. And as a result, it's therefore taxed in that jurisdiction. Now, a fixed place of business can include, but they're not limited to, offices, factories, branches, workshops, quarries mines. These are the definitions from most of the tax treaties. With a relatively standard set of definitions in most tax treaties about what is a fixed place of business. An employee's being able to conclude contracts can create a permanent establishment or branch in most countries. We often have a situation where people will go and work from, they will send employees and possibly work from home, because we have hybrid working now. And I always have the question does that create an office for business? And the short answer is yes, it can in most jurisdictions. If you have employees that have moved cross-border and are working from home in a rented office, even if the business isn't paying for that rented office, you may have already triggered a permanent establishment and therefore be subject to taxes in that country and then moved away from any kind of non-taxable presence in that country. Dependent agents is not necessarily relevant to every single sector, but there's lots of sectors where companies will contract with an agent to sell products or sell services on their behalf in a country, and if that agent can include contracts on the company's behalf, often that will again create a permanent establishment within that jurisdiction, and we move on to the next level of profits being taxed. Some of the challenges that come from permanent establishments is often about kind of the accounting systems that are in place. Establishing what profits are actually attributable to the permanent establishment in the branch can be a challenge, particularly if it's a business's first venture into working cross-border. They may not have the systems set up in the right way to be able to to separate out profits from establishments. So it's really important that some thought and advice is taken around how to set those systems up in the right way, so that establishment can be reported correctly in that jurisdiction. It will often need to be registered for tax as a separate entity over the years, not a different legal entity, but it will need to be registered within that jurisdiction as a separate taxable entity. Thirdly, and I suppose the most permanent form of presence in a country is company residence, and often once we get to this stage, we're looking at setting up subsidiaries in those countries so that we can separate the company residence from that of the whole co, and we don't end up with dual taxation issues. And we'll talk about why that's an issue later on as well, because dual taxation is a bigger issue now than it ever has been. And if a company does become dual resident, there are some quite nasty tax answers that can come through the structure. Historically, a company has always been resident in the place that it's been incorporated, or it's effectively managed and controlled, so that they're the main point of control for that business. And the effective management and control test was always the tiebreaker test in most double tax treaties. So that was the point that everybody looked at. So, well, if we're resident in two different countries, we don't want to pay tax in both countries. We're not going to be dual tax resident. Effective management and control trumps place of incorporation. Therefore, the tiebreaker test. That has now changed. Effective management and control is always the tiebreaker test. Due to the BEPS programme, most double tax treaties have been changed and updated now to include what they call a competent authority test. And that means you have to write to the top tax authorities and ask them where the main place of residency is for that business, and the tax authorities have to agree with each other where that may be. And it probably still will be where the effective management and control is. But in our experience, what that has created is a situation where it just takes quite a long time to get this agreed. So where before we could take a view, we could take some advice from tax advisor or an accountant and say, well, we know that effective management and control is the tiebreaker clause, so that is where we're going to elect as our main taxable jurisdiction. That's no longer possible in lots of jurisdictions. And BEPS has changed that, and we now need to write to the local tax authorities. Companies are taxable on their worldwide income, and because of this issue around dual, being able to be dual resident and potential issues around applying the tiebreaker test, this can result in double taxation issues, lower withholding tax rates not applying as a result of lack of agreement from tax authorities. I did have a couple of years ago a case where the US and UK tax authorities were arguing over the residency of a company. Clearly, they have no concept of cost. They don't care how much it costs to have this argument. The company really did because they were having to pay for professional advice, legal advice, tax advice to be represented in front of both tax jurisdictions. The tax authorities in those jurisdictions just couldn't agree with each other, and it went on for years, and it can be quite a painful process. So certainly moving to a competent authority test is not seen as a massively positive thing. It's seen as a step that will slow down agreement on residency issues and possibly disagreement with tax authorities to try and pull profits into the jurisdictions. The tax administration authorities in each country, their main task is to make sure that they tax as much as possible. So it's not seen as a positive thing by most tax advisors. Why is dual residency such an issue? I said it's a problem. So when a company is dual tax resident, it's subject to tax in more than one country. It creates issues around the complexity. It has to file multiple tax returns. It may not be able to claim double tax relief at that point in time. and there can be issues over taxing rights and authorities agreeing which jurisdiction those profits should be taxed in. Where we have withholding taxes, they are not automatic. If a company is dual tax resident, they may not be able to apply a lower rate of withholding tax, which means they could suffer higher rates of tax or even additional taxes that they can't offset, increasing the cost of doing business in that country. And actually, the most important thing for any UK company is dividend exemptions do not apply to dual resident companies. So if you are a dual resident company and you're receiving dividends from overseas subsidiaries, you cannot automatically assume that those dividends are tax-free in the UK. They're probably not, and could result in significant tax liabilities. It is probably the biggest overlooked issue for dual residency for any issues for SMEs. So if you're receiving dividends from subsidiaries that you set up and the holding company dual resident, then those dividends can become taxable. Clearly, what we want to do is get that competent authority test agreed as quickly as possible, but it takes time. The two authorities have to agree with each other. The process is still relatively new. The tax has only come in over the last couple of years, so tax authorities are still getting used to some of these requests coming in and how best to deal with them. So it can take some time, so you need to build it into the process of setting up these entities and understand that maybe dividends shouldn't be paid or interest payments shouldn't be made because we're not going to get the benefit of dividend exemptions and lower withholding taxes in those jurisdictions. Double tax treaties, we will have a conversation about, as I've said, the general concept of international tax is that you should only be subject to tax in one jurisdiction. I've shown a couple of examples of where that might not be the case, but most tax authorities strive only to tax profits that should probably be taxed in that jurisdiction. And they are set out in what we call a double tax treaty. And if you haven't come across a double tax treaty, it is a very long document. The UK has double tax treaties with more than 130 countries, making us one of the largest treaty networks, which is why the UK is used quite regularly as a holding company jurisdiction, because it has so many double tax treaties. And effectively, these are agreements between countries which dictate where the income should be taxed and when certain reliefs or exemptions are available for those in other jurisdictions. So the purpose is to avoid that income being taxed in more than one jurisdiction. Sometimes you also need to consider local rules and also the types of entities that we're utilising. And an example of this is looking at, for example, LLCs in the US. So if we have individuals invested, UK tax resident individuals invested in LLCs in the US, well, the US tax authorities treat LLCs as what we call an opaque entity. They treat it like a company. The UK tax authorities treat it as a transparent entity. We treat it like a partnership or an individual. Because we treat it differently, we can't offset the taxes. So if a UK individual receives a dividend or a profit share from a US LLC, which has already been subject to tax in the US, you can have issues offsetting those taxes against the individual's income. So it's important to understand what entities you're dealing with and what the local rules are. So how are those entities treated for tax purposes in those jurisdictions? Tax treaties include beneficial rates for withholding taxes. So withholding taxes is a tax paid on a payment to an overseas individual or company. Typically, they relate to dividends, interest, and royalties paid to foreign individuals or foreign entities. Some countries do impose withholding taxes on other services, such as technical services. India is a good example of this. So you always need to take local advice on withholding taxes. Our standard rate in the UK is 20%. But for example, all of our dividend payments from a UK entity to any other foreign entity won't be subject to 20%. It'll be subject to a 0 rate tax. because we don't apply withholding taxes for dividends, typically from a UK perspective, and rates range for other countries for interest and royalties from 20% all the way down to 0, depending on what has been negotiated. So it's obviously a very useful document, and something that we refer to on a very regular basis when we're looking to advise clients in countries. The first thing we will do is to pull out the double tax treaty relating to that country and just understand what has been agreed between the tax authorities before we can advise those clients. How do entities get relief? Typically, there's 3 types of relief available under the double tax treaty. There's an exemption relief, so income is exempted in one country and just simply not included in the tax return. The unilateral relief, so the foreign tax suffered is deducted from the tax payable in the country of residence, reducing the local tax due and effectively eliminating double taxation. There are instances where neither of these are available, and the entity can then claim expense relief. So the tax is deducted as an expense, reducing the profits of that entity rather than as a direct reduction of tax. Not the most efficient, and it isn't technically full double tax relief. An example of this is state taxes in the US. So federal tax would be covered normally under unilateral relief, or full relief would be available, but typically state taxes are not covered by unilateral relief. So we seek to claim expense relief because at least we get some relief of 25% corporation tax rather than none at all. And that's just simply because the state taxes aren't covered by the double tax treaty. Moving on to BEPS and transfer pricing. So BEPS is a project that's been ongoing for a number of years now. I think it started in 2019, off the top of my head, I can't remember the exact date. It stands for Base Erosion Profit Shifting Rules, and it's an agreement between pretty much all large European countries are part of the BEPS programme, and it's looking at predominantly large businesses shifting profits to low tax jurisdictions and preventing that from happening. So on the face of it, doesn't affect small businesses. So BEPS applies to groups with turnover greater than 750 million euros. The one if we have group turnover less than that, or from an individual entity have less than that. But as I mentioned earlier, BEPS has changed pretty much every double tax treaty, and then those that haven't changed to date, I'm sure will be adopted in due course. And this is just one example of some of the changes in the tax treaty, where that test for residency, the central non-payment control test, has been removed as the tiebreaker, and it's been replaced by the competent authority test. So we have to check what changes the BEPS program has made to double tax treaties, because once those changes are made in the double tax treaty, they apply to everybody, not just small businesses. And we are starting to see more and more changes coming through the BEPS program to change double tax treaties between countries. And it's the biggest change that we've seen in certainly my career in tax of double tax treaties. Let's say they have an impact on every single business, so it's important that we keep a check on what changes come through the central monitoring and control test, is just one example of that. The more interesting one is transfer pricing. So typically, the transfer pricing regime was only applicable to businesses that turned over, or groups of companies that turned over £250 million. That was until the UK tax authority brought in a set of rules called profit fragmentation rules, and effectively this is a transfer pricing regime for small and medium businesses, and it just seeks to tax positions where small and medium businesses that were typically outside of the usual transfer pricing legislation, where there was entering into transactions to try and either create a mismatch of tax, i.e. to create a deduction in the UK, but create income in another jurisdiction that wasn't subject to tax, or just generally payment policies, where the overseas tax paid is less than 8% of what would have been paid in the UK. The UK tax authorities just said, no, this is too abusive, and we don't care how big the company is. We're going to bring in this regime, which means that you need to have some proper documentation around your transfer pricing policies. You need to demonstrate what is the commercial reason for that transaction if you're paying less tax in an overseas jurisdiction, and demonstrate that it's not tax motivated. Otherwise, we're going to effectively create a transaction on the other side of that. So, for example, if I'm shifting profit for jurisdiction where I'm not paying tax, or we're going to deny the tax relief available in the UK, you're not going to get a tax deduction for the expense you generate in the UK. So we're going to remove the mismatch that occurs and stop businesses from abusing the rules. So all businesses, regardless of size, now have transfer pricing rules that they need to consider and adhere to. These rules have been in place now for a number of years. I'm still finding myself explaining to businesses that are moving cross border that they're not exempt from transfer pricing. There's still accountants and tax advisors out there that don't get this right, advising their clients that they don't need to consider transfer pricing when sadly they do in certain circumstances. Certainly the biggest area that we need to consider is the cross-border movement of employees, global mobility, we refer to it, and it has a massive tax impact. Hybrid working, video conferences have made it much easier for people to work wherever they want to do. The United Nations estimates that 232 million people, or 3.2% of the world population, live and work abroad. 42% of employees would like to work from abroad, with millennials being the most likely to want to do so in a recent survey that was executed. We're expecting this to increase with the impact of AI, the change of people's roles, with the access to global markets being made much easier. I suspect that 42%, but also with the demographic of workforce changes at the moment. People like me who are at the older end of that generation these days tend to like to be settled and where we want, but as we get more millennials coming through and then younger generations coming through, I can imagine that 42% of employees wanting to work abroad could go up and up and up. So it's just something to be aware of. The tax implications can be quite challenging to deal with. However, the general rule of thumb is that employees taxed in the jurisdiction that they undertake their duties. Now, that might actually be different to where they are tax resident personally. It could be that they are personally tax residents in the UK, but Tuesday through Thursday they fly out to France to undertake their duties for a French branch of their employer, and therefore are very likely to be subject to French taxes and possibly social security in that jurisdiction as well. It creates much more complexity for employers. They need to register in those jurisdictions and report taxes or the tax authorities. Some countries have mechanisms where employees can administer the payroll on their own behalf. So the UK certainly has that. If you do not have an entity in a particular jurisdiction, the employee or the director in that location can administer the payroll on behalf of the company, which can sometimes make it a little bit easier. And it's important to be aware that social security can follow different rules. And each country has different requirements from a social security perspective. Also, it often falls outside of the double tax treaty, and it may be that double tax relief isn't therefore available for social security contributions. So it's important to take local advice on social security and mobility issues to make sure that we're following the rules. People understand that wide ranging draft of rules, and every country can be slightly different. Some of the other considerations when you're sending employees cross-border is you might ask them to actually go. They may not request it themselves, and you might be asking them to go to a jurisdiction that has a higher tax rate than the UK does. If you do, it's very likely they're going to ask you to compensate them for the additional taxes they have to suffer. This is what we refer to as tax equalisation. And the employer will be asked to effectively compensate and pay some of the tax on behalf of the employee. Most jurisdictions have a mechanism in place where tax equalisation can be undertaken in an efficient manner. It's not seen to be a benefit in that country, except for the highly complex set of rules around low tax arrangements. There'll be multiple tax returns and a higher compliance cost inevitably. I've said this a couple of times now, we've gone through this presentation. There's always higher levels of complexity when we move cross border. I think most of the people on this call are lawyers, so it won't be a surprise to you that contractual arrangements can cause all sorts of issues when we move cross border. We used to have a concept of dual contracts at one point to separate overseas activities from UK activities and make sure that everything is taxed in the right pot and the right tax authorities are being taxed. So you can end up with multiple employment contracts being needed for cross-border employees if they work in multiple jurisdictions, and pension and benefit requirements change dramatically from country to country, and you need to make sure you're aware of it. Things like visas, etc., will become very significantly more difficult to get if you're bringing people into the UK, and also a little bit more difficult in other countries as well these days to get visas for employees. And I did talk very briefly about VAT, import and export duty and the compliance cost. Since we left the EU, we've still followed the single market VAT rules and are still part of the one-stop shop process that exists within Europe, where you can effectively file one VAT return in multiple jurisdictions, which is really helpful and really useful for small businesses, particularly if they're operating in multiple jurisdictions. We are still part of that, thankfully, at the moment. How long that will last for is to be determined. It could fall away at some point. And if it does, as I said before, often if you're not resident in a country, then registration limits disappear and you need to register as soon as you start operating in that country. So it can create a huge amount of compliance burden and compliance cost for small businesses, and it can be hugely onerous on small businesses. I've seen businesses before that have taken the minimus limits themselves and just taken a view that the cost of registering and complying in that country is too high compared to the cost of actually being compliant, which is obviously a difficult concept for me as a tax advisor to help advise clients, because we can never tell clients to be non-compliant, and it can create issues around money laundering and general fraud. So it can be quite a challenge when companies don't want to register in countries. I'm just conscious of the time. I think we've got about 10 minutes left. I did say I'd leave some time just in case there were any questions, but I think that probably covers most of the key concepts that I want to cover. There is a QR code there. There's a very old picture of me, and you'll see from my picture now. I was much younger back then, but here's my contact details, the QR code there if you do want to contact me and discuss any of the concepts that we've talked about today, or any other issues around international tax. Feel free to contact me. I think we're going to circulate these slides. Abby, is that correct?
Yes, we will do, yeah.
So don't worry if you miss it. There are no questions in the chat box, but if anybody does have any questions, do feel free to go into the sheet, and then if we manage to move anybody over to panelists so they could speak.
We've given them the option. They had to accept the invite as panelists, and I think most people are just happy to listen today.
Perfect.
Thanks, Anthony. That was great. Sorry, I was a bit slow accepting the invite. The only question I got was how the UK compares, HMRC compares, thinking about the G7, we're one of the centre-left governments, and how does the UK HMRC compare in terms of how aggressive governments are being and tax authorities are being in terms of policing taxes? I don't really ever know how we compared to our peers in terms of tax breach.
Yeah, well, I'm going to answer that question slightly more widely in relation to how does the tax regime in the UK compare, and then how does HMRC compare. The tax regime in the UK is seen to be a relatively low tax jurisdiction. I know everybody will be shocked at hearing that, but actually our tax rates are not horrendously high compared to some other countries. They're clearly not the lowest by any stretch of the imagination, but certainly when we start looking at things like corporate taxes, we are kind of mid-table, I suppose, in the European, in the larger European countries in relation to our rates, as there's a number that are much higher and a number that are much lower. Tax authorities in the UK, there's two aspects to your question, I think, is the service that we are provided by HMRC seem to be very poor compared to other tax jurisdictions in other countries. They often tend to be much better funded, and I think it has an impact on the actual question you asked, is how aggressive are they? Because our tax authorities are massively underfunded, they tend to be very, very aggressive. However, that said, I've been involved in two very big inquiries in my time, one with the Indian tax authorities and one with the Italian tax authorities. The Indian tax authorities was an interesting one. They turned up with police and guns, locked the door and said nobody is going home until we concluded our tax investigation, having told nobody they were going to turn up, and kept everybody there for 5 days. We had to negotiate with them to release people from the building to allow them to go home and see their families. I had a similar instance in Italy. So if you ever meet the tax authorities in Italy, they carry guns as well. And they turn up, and when they're doing tax investigations, they tend to be armed officers there. So it can be quite scary in some other jurisdictions. So we're relatively soft touch in that respect. The UK is definitely becoming much more aggressive, but I think it's more driven by having an underfunded tax authority and the push for the government to collect as many taxes as possible. The move in other countries has been a zero tolerance on avoidance. I mean, Italy is known for being a jurisdiction where tax avoidance is one of the country's favourite pastimes. And therefore the tax authorities take a very dim view on people trying to purposely avoid paying tax, although it happens quite regularly. But hopefully that answered the question. We're a relatively light touch, I think, from an investigation perspective, but the tax authorities do like to send around quite a lot of nasty letters and make a lot of noise. But nobody's going to turn up to your doorstep and lock your employees in the building, or turn up with armed police officers, which they do in other jurisdictions.
Interesting. Thanks, Anthony.
Great. Thank you, Anthony, so much for your time this morning.
No problem.
As you mentioned earlier, we'll circulate the slides, and your contact details are up there. So if anyone's got any questions, they'll be in touch. But thank you so much.
Thank you. Take care, everybody.
Bye.
Have a good day.
Thanks. Bye.